So on the judges panel, we have Judge Robert Kim from Kona, Judge Henry Nakamoto from Hilo, both circuit court judges, Judge Kimberly Taniyama, District Court in Kona, and Judge Darien Nagata, Family Court in Hilo.
Oh, we saved that one for Jeff. This is for Jeff.
And then, of course, Judge Wendy DeWeese, Circuit Court Judge. That's how West Hawaii Bar does it. You thought you were only getting 5 judges, now you got 6.
Never a free lunch, Jeff.
Not dressed right.
All right, so to start off, I'm going to invite all the panelists to tell us what they think about 704, beginning with Judge Kim.
Thank you. Thank you all for coming. It's an important topic. Let me just say, as the administrative judge for the Third Circuit, that the judiciary is not the end-all agency, department, branch of government that can solve 704. And the mission is being thrown on our shoulders to basically solve all of the problems regarding diversion and the like. Luckily, in Hilo, they have a jail diversion program. We don't have one in Kona. We don't have facilities. As Danny Noy said many years ago, Hawaii is an 8-room house, and everybody lives in one room, and that's Oahu. And all the facilities, all of the programs are located on Oahu. That causes stress for us, having to arrange with transport, overworking Dr. Shields, who's only one person coordinator for the whole island that's 100 miles separated. And so, if anything that I could say from where I'm sitting, we need to contact our legislators, we need to contact people in power to support Department of Health in providing places for us to send people. We had a meeting a long time ago with Dr. Leifman from Miami, who has a jail diversion program, and he diverted people, and it works. And the reason it should work is it's not helping the people who have mental health problems, and it is overcoming our ability to manage the jails. Our jails are horrendous. People are killing themselves in jail. The individual who last killed himself by suicide was up for 704 evaluation, but didn't have it in time. So what I'm trying to say is that we need to work in collaboration with the Department of Health to solve this problem, because drugs, 704, are the greatest problems facing us. And frequent flyers is the term that all of we judges use for these people who keep circulating back in. We know them by first name. We have to solve this problem. That's what I would say. Thank you.
I agree with all what Judge Kim said, and I appreciate everyone being here. I'm impressed that we got a full room for both Kona and Hilo, and around Waimea, also the whole island. Because of the shortfalls we have, we all have to, as everyone's saying, communicate with each other and collaborate rather than litigate. And I think we do a lot of that throughout the courts as something we need to do to try to help solve this situation, not make it worse. I want to just appreciate everyone coming here today and really interested or willing to work on this issue, and I appreciate all of you being here.
I basically do district court, so we see the lower level cases, the Act 26 type cases. I guess what I'd want to say is, for some of these people that are coming in all the time, on a CT2 or some sort of CPD4 or they stole a bag of potato chips is to maybe, if you can, plead them out. You know, even though they may be borderline, is to just get the case done, get them out, get them down the road. People can be of two minds about that. I know some defense attorneys are afraid of that CT2 or that CPD4 being the predicate for a habitual property crime. But I think if the prosecutors can maybe back off on that, that will alleviate that issue. Because I know that's one of the reasons that the defense attorneys don't want to plead their 704 clients out. So sometimes, you know, there are good days and bad days for 704 clients. Sometimes they'll be able to get through, sometimes they won't. I'd encourage you to try to get them through, get them out of the system, because, as Judge Kim said, it's a horrible situation. You can't put them in. There's no facility for them here. And I think the best situation is that they're just not involved at all. So that's my take. Oh, yeah.
I don't think I have much more that would be different from what the judges have said so far. I would say, though, that I appreciate in Kona, because I'm in district court as well, and we see a number of these individuals coming through on a very regular basis. We have a good team that works well together. They're very open to being creative when the situation calls for it, working within the parameters of the law. We're not that creative. But they communicate very well. They're very responsive with each other, and I think that's to the benefit of the clients, because I also will tell you, I get frustrated with the lack of resources that we have available, that these individuals need assistance. We don't have a lot of assistance to give them. They don't belong in jail, and as judges, sometimes it's hard. We have to balance appropriate resources, needs of the client, protection of the community, other considerations. That there's a whole bunch of factors. And for our Act 26 cases, for example, they're held. And I think the way the statute was designed was to have them held at a Department of Health facility, which we do not have, which then means by default, the individuals in the Third Circuit are held at the facility of the Department of Public Safety, which may not be the most appropriate place for them. But if we don't, then the exams don't necessarily happen. Not a perfect system, but I will say the team that's in Kona, they do the best they can with what they have, and I completely appreciate that.
As we all know, the Third Circuit seems to have a disproportionately high number of 704 cases in the state. I don't know why, but we do. With that being said, with everyone that's showing here from Kona, from Hilo, it shows our commitment to work with these 704 cases. And I think what we talked about this morning, the communication between and the teamwork between prosecutor, defense, and Dr. Shields, all of our other agencies, sheriffs also, we need to keep that up and really appreciate everyone's efforts. And the more we can do to work together, I think hopefully we can at least speed these cases up and get the correct results sooner than later. Keep it up, everyone.
So I guess one of my comments would be that I hope what people come away with from today is that we should all be very thoughtful about 704s and not just use it as a vehicle to kick the can down the road. Be mindful of the impact of asking for a 704 if your client is in custody, because even if you're going for penal responsibility, it could end up delaying your client's trial and the individual could sit in custody. So I hope that the attorneys are going to be thoughtful about under what circumstances they ask for these types of evaluations. Also, because there are a lot of cases that do really need resources to be expended on the evaluations, and if we just sort of willy-nilly ask for evaluations, it impacts the examiner's ability to do good jobs on the cases, the big cases, the cases that do really need their time and attention. And also, I think for me, and I'm interested in, after today, hearing from you folks, I'm having to be more sort of stingy with my time on the 704 cases, because not only are the 704s increasing, but all of our other cases seem to be increasing as well. And I seem to have continuously less and less time to manage the 704 cases in the courtroom. And so I have been trying to be thoughtful about when and how and if I schedule review hearings, for example, in CR cases. Do they really need to come to court every 3 months, every 6 months, or at all? If they have a probation officer and a case manager and a doctor, why do they need to come and face the judge? And so I am trying to be thoughtful about the cases that I keep on my calendar as well. And I think that we're going to be sort of pressured into that just because of the time constraints that we have now with all of the 704. So that's just my sort of input. Thank you.
All right, and the first question I have for the panel as a whole, it actually relates to something that's kind of been touched on with the attorneys panel, fitness versus capacity and doing one before the other. We've already discussed how fitness definitely tolls time and suspends proceedings, whereas a procedure just examining for capacity doesn't necessarily. But Rule 48C does say that a period of time involving irresponsibility examinations is a period of time that's excluded from Rule 48, and further down, I believe it's in Rule 48D. One, it's actually a per se excludable period of time if the word it uses is for mental examination. So what are the judges' take on what happens when a defense attorney moves just for the issue of examination, and what do you do or just for the issue of responsibility, what do you do in your court when it comes to suspending proceedings?
God, I got the wrong seat. In my court, that's interesting what you just said. If you go for fitness, it tolls time. If you go for capacity, it doesn't, unless you can argue otherwise. So make your case.
Who has to make the case?
Whoever wants the 48 total.
Judge, I have a question to follow up with that. But isn't it true that in order to move for penal responsibility after the fitness, that there actually has to be made a finding, and then the argument actually has to be made as to why? Like there has to be made a finding related to penal responsibility so that you do get the examination. So technically, wouldn't it be on the defense first, and then the Rule 48 argument comes in from the prosecution? The two separate arguments?
If they do the fitness first, time is told.
Yes.
If they ask for capacity, they have to establish why.
Yes, that's where the
But
first argument comes in from defense, right?
Right, and my court, unless you can convince me otherwise, is it does not toll time.
Absolutely.
And so that also goes with the caveat that Data was talking about. Sometimes you may find that you want to go for a neuropsychological examination. And I think Judge DeWeese talked about you can also go for a medical evaluation if it's a organic problem, impulse control, head trauma, PTSD, war veteran, whatever it is. So each case you have to come in and you have to explain to us what you want to do. And so that's what happens in my court. I'm not saying that's the right way, but that's the way I see it so far.
So then Judge, with a follow-up question with that, if the argument then basically becomes to the prosecution for the Rule 48 that is now running, is it on the judiciary to make sure that we're still set for jury trial, whether that comes back or not, before Rule 48 holds?
At least the people who practiced before me, the defense knows that they need to continue the trial if they're going to hit it. But let me ask this, how many attorneys out there disagree with that? How many people think that they don't have to worry about the trial date if they just go for capacity? I don't see anybody thinking that.
My experience has been,
Except for Jim Bivens.
my experience has been that when I file for fitness only and then I come for capacity later, prosecutors will now file at the fitness return date a motion to set the trial within Rule 48. So what I do is I file a motion to continue set it for the same date. So I'm not sure what everybody else does, but the practice has been for the state to file a motion if it's bifurcated.
Right, but I think, okay, so I agree with your analysis. But what I'm also seeing from the prosecutor's side is that they'll go to district court and they'll start it off. Somebody will make a request for a 704, and then it'll come back and it'll say the person is unfit. And then what'll happen is prosecution will file a information or an indictment while that is still pending, and basically try to obviate that because they're concerned about when it does come back, it's going to basically push them up against whatever deadlines that they're worried about. And so in my court, if that happens again, I'm going to find that the district court made a finding of unfit, and that person is unfit until it is set aside. But that's only me, because I am not in favor of that practice. If they're found unfit, you need to find them fit, even if you go to a different court, because there's still a standing court order. So these are the little nuances that you need to be aware of, because we're watching, we see it. Okay, thanks.
So regarding the question regarding the motion or request for penal responsibility after finding of fitness, I also agree it does not toll the Rule 48. However, so we have a trial set and defense does not waive time or does not continue, and the report's not ready, I think at that point defense has to make a choice whether to move to continue for completion of the report or go without that report being done.
Okay, district court here. So I'm dealing with mostly petty misdemeanors and jury waived misdemeanors. So just go ahead and order the fitness and the penal responsibility at the same time. We'll get it done in one report. We'll get it down the line. We'll be done with it. Don't bifurcate it. I'm not going to give you jail anyway. So let's just get it done,
Frequently, our motions are coming off of our custody hearings. So frankly, the issue of capacity and capacity and fitness, there's a proximity in time. So it kind of makes sense to have the motion for both at the same time. And again, district court, it doesn't make sense to really draw it out, in my opinion, but I could be missing some really significant point. I think in district court, it does make sense, unless we're talking about the Act 26 matters, to move for both at the same time. And please don't move for both when it's an Act 26 matter, because I will deny it. I will just give you fitness.
In family court, we don't have, it's not that we could never, because we could have a contempt of court, a petty misdemeanor, but we generally don't have Act 26 cases. I've never had a situation where there was a request to have just fitness, and then the responsibility after. So it really is an issue in my court.
The only thing I'll add is think about, as counsel, when you're going to move for these exams, because I will, if you bifurcate and ask for a fitness exam and the person comes back fit, I will reset jury trial within Rule 48. And so if you wait until after the pretrial conference or 3 weeks before your jury trial date to move for fitness, and your person comes back fit, I will short set your jury trial within 3 weeks if that's all I have left on Rule 48. So don't wait. I would just ask defense counsel, for your own sake, figure this out early on if you can, move for the fitness, And then if your client comes back fit, you'll have 3 or 4 more months left before Rule 48 runs out. Otherwise, you're putting yourself in a position where you're going to be asking your client to waive Rule 48 so you can get ready for trial, and that may have some implications for your client. So I would just ask counsel to be mindful of that particular issue. Thank you.
And as I did earlier, I'm going to piggyback off that comment because it goes straight to one of the rules that the attorneys have to follow as part of the rules of professional conduct. Rule 1.3, a lawyer shall act with reasonable diligence and promptness in representing a client. That goes also to fitness, asking for fitness, and penal responsibility examinations. So that's something to think about. Are you, if you wait until a month before the trial, are you really acting with reasonable diligence and promptness in representing your client? The next question I have, again for the whole panel, and we can start at the other end so Judge Kim doesn't feel like he used to go first. So I'll start off with Judge DeWeese. To comport with due process, this is a quote from a case in Illinois. To comport with due process, the court may not merely accept the party's stipulation to the expert's ultimate conclusion. Although oftentimes in courts, at least in Kona, we do stipulate to the doctor's reports and the court accepts them and finds the defendant fit, for instance. What is your interpretation of that quote from the Illinois case, and how do you ensure that experts' conclusions are actually valid?
So I think what I take that to mean is that the court cannot delegate its responsibility to make its fitness finding, or in a bench trial, responsibility. But let's stay with fitness. So in other words, it is ultimately the court's responsibility to consider the evidence before the court, which comes mainly in the form of doctor's reports, and to, based on the evidence, make the finding, and that the court cannot say, well, just because 2 out of 3 say this, or 3 out of 3 say this, therefore it is so. I think the court still has an obligation, because a lot of times I've had cases where it's 2 to 1, and frankly, I'm more convinced by the 1 than the 2. And so that's how I interpret that, that we are not able to delegate that responsibility, and that it is the court's responsibility to consider the evidence and make the finding. And I think there was a second part to your question, but I can't remember what it was.
No, I think you get it.
Okay. I'd agree with Judge DeWeese, but I would also add that the parties can stipulate the report into evidence and call the doctor and cross-examine the doctor, and then the judge will make a decision. So the doctor may have their conclusion, but it is up to the parties to cross-examine, elicit whatever evidence, whatever testimony from the doctor, what's the basis, and then it's up to the judge to make a decision from there.
I would agree, but I think, and I'm not sure how you do it in Hilo. In Kona, we actually meet before we have our calendars. So before we actually call the cases on the record, we have a discussion. And so sometimes these issues where there might be some concerns, if there's a stipulation or not a stipulation, if there's some issues or areas of concern in the reports, we actually discuss it before. I know that's not on the record. Sometimes we do put it on the record, right? But I agree with what's been said. I just wanted to add that we actually work through and sort of navigate the concerns that we have when reviewing reports. We don't always agree, right? So we share our thoughts and we have a discussion, and then ultimately, yes, it would have to be the decision of the court.
Can I get the quote one more time?
To comport with due process, the court may not merely accept the party's stipulation to the expert's ultimate conclusion.
I'm not sure I agree with that, but make both parties stipulate, then the court's out of it at that point. You have defense and prosecution agreeing that a fact is a fact, then I'm
not sure I agree with the premise. So I don't do the 704s. Judge Laubach typically does those. But in my courtroom, if both sides are agreeing to something, then that's what it is. I'm out.
When I heard that quote, I guess it's two things that I think of. One is what Judge Hawk said, if they stipulate, not necessarily only to the reports, but to the conclusion that, say, defendant is fit, I just go with it. If they stipulate to the reports, and like Judge DeWeese says, it's 2-to-1, and they assume I'm gonna go with the 2. In those situations where there's no agreement on what the ultimate question would be, we have pre-trials on our 704s, but not all the cases. And when we do have these highly contested ones, Dr. Shield also zooms in on those. We kind of talk about it beforehand, and I'll let them know that it's not a guarantee. I still have to listen to the evidence, look at the exhibits. If we are at a stiff fact trial, but it's not a guarantee I'm going to go 2-1.
I agree with that. It's our call. And so my question to the practitioners are, when you read those reports, are the doctors always right? They always hit it on the nail. You're sitting next to the person, you're talking to them, their eyeballs are spinning around, you've met with them, they meet with them for 1 hour, review the notes, and say this person is fit, but this person is not fit. And so if it's 2-to-1, we have the authority to go with 1. And that's all it takes, so just be aware.
All right, and the next question for the panel, and on this one I'll just see who wants to answer. And this is also, this is a quote from Droop v. Missouri, which is one of the main U.S. Supreme Court cases concerning the issue of fitness and mental health in criminal courts. The quote is, "It is nevertheless true that judges must depend to some extent on counsel to bring issues into focus," talking about mental health and fitness issues. What do you use as judges what do you rely on as judges when you're dealing with mental health and fitness questions? Who wants to go first?
I think that it really is an issue in the mental health court. Like Judge Kim said, the doctors might have the record, see the defendant for an hour, but counsel, I would assume that you folks would know more than the court what's going on. So I think it's imperative that counsel bring it to the court's attention, because they might look perfectly fine when I see them in court for 5 minutes, but I don't know what's going on even in the hall or interaction with anybody else. So we really depend on counsel to bring it to our attention, and we appreciate it when you folks do. So don't be afraid to say, "Hey Judge, I think you're getting it wrong because you may have missed this that went on." So at least in my court, I really depend on counsel bringing those things to the court.
And so for me, I think, sometimes judges are in a pretty unique position, I think, to see how the defendant behaves in a courtroom. And, one of the things for fitness is, can the defendant withstand the stresses of trial? And the doctors don't get the opportunity to see the defendant in a courtroom, in a formal setting. And a lot of times I've had cases where, the doctors opine the individual is fit, but when we have a contested hearing and you ask the doctor, well, do you understand that a jury trial isn't just 1 day? This is a felony. This is going to be 3 days, 4 days, 2 solid weeks in a courtroom. And sometimes you see the doctors kind of go, oh, they don't always consider what is involved, especially in circuit court in a felony trial. So, I think it's important to try to flesh that out a lot of times. And so I, to some extent, will rely on what I see in the courtroom. And then if counsel is not moving for fitness, maybe ask counsel to approach and say, have you thought about this? This is kind of what I'm seeing. Ultimately, the court is within its right to sua sponte move for a fitness exam as well. So I would not be afraid if I saw signs in my courtroom of doing it either.
Anyone else? And we're kind of running out of time. Are there any questions from the folks in the audience? Oh, sorry.
Sorry, I want to change subject for a moment. One thing you need to know, because Judge Nagata hit on it, is that we have a high number of 704s. But when I talk to my Honolulu counterparts, there's a different culture up there. The defense attorneys in Honolulu will do anything not to get a 704. Why? Because if they go 704 and they're in custody, they'll languish in there. And for a lot of the smaller cases or first-time cases, they'll try to get their clients to be as sober or conscious as possible so they can plead them out, get them time served, and they get them out of jail. That's different here. Attorneys over here feel that I can take this off of my calendar and I'll come back in about 8 weeks. Okay, so that's a culture thing. So I just want to bring that out, that I see that sometimes, not all the time, sometimes it's important. Lastly, I just wanted to bring up this issue regarding the sheriffs, okay? Because we have to send them off island many times, I just want to bring up for the practitioners, number one is that we are in the process of working with the sheriffs. We contacted the clerical supervisor. She tells us that 2 weeks notice would be great, but at least 2 days notice for proper transfer to bring them from Honolulu to your court hearing. This is important. Also note that when you're doing a 704 and the person, you say, oh, I'm finding them fit, and therefore they can come out of HSH or the like, let us do that finding, because what'll happen is the sheriffs will not bring them out because they're not in custody any longer. And so what I've done in those situations is continue that decision till the following week so we can get that writ out there and then bring them back. Otherwise, your client is going to be left on the street without identification and the like. So know that little trick. If they're coming out of a drug treatment, same thing. If they're not in custody or custody type, they won't bring them back. So I just want to give those practice pointers to the attorneys. Thank you.
Are there any questions from any members of the audience? Leslie?
So Judge Kim, I know this came up in your courtroom. Can you talk about the responsibilities of the parties to distribute orders, specifically orders for transporting people to the hospital for commitment, and then transporting people from, say, a facility to a group home?
Yes. So we in the judiciary, at least in Kona, we just went through that analysis. And so just for the practitioners here, if the court is doing it, then we send out the fax, okay? If legal documents is doing it, they send out the fax. And we have a set fax distribution list. What we found is that this person, Pohai Mo'ava in Honolulu, was not on that list. And so what happened was, you send it to the sheriffs send it to her. Now we've added her to the list, so now she's gonna get it. She says she doesn't mind if you send them a fax. If you send them an email, it's just added to her, because she'll know from her list who needs to go and who doesn't. And so the responsibility is actually with us. Once the order goes, it's the court that does it, but I don't know if Hilo has the same view.
I agree.
I agree.
I agree.
Judge Kim, it didn't come up previously, but the information for Pohai is in the PowerPoint. So I don't think we showed the slide earlier, but that information is in the materials that everybody here has today for Pohai Moiva.
Yeah.
Yeah.
Or contacted.
Yeah, contacted her,
Yeah, we've provided it to everybody.
Sorry, I was working.
It's okay.
Well, no, I don't think it was mentioned. That's why I'm saying it now, because it wasn't mentioned earlier, but it is in everybody's materials.
All right.
It's for the panel. My question is, as you've mentioned before, that we have an extremely high number of 704s on this island. I don't know if people understand that we rank probably around, our population is more like Hawaii and Maui combined, but we have 40% of the panels coming out of the state, coming from this judiciary. So I'm just wondering, any ideas besides these trainings on how we can help address this to bring this in more in line with the other circuits?
Anyone want to take that one?
We need jail diversion, so we need to have facilities to send them. That's the tennis ball going back to DOH. Second is that we are in the process, we're not there yet, but we're contemplating having probation who sets up the 704s, try to give us an Excel sheet so that we can look at it and then provide the judges with an Excel sheet that'll say, Joe Doe has had 13 704s, and in each one he found fit. And therefore, you're not looking at an individual and you can say, counsel, he's been found fit 13 times. How can we move forward? So that's one way. Other than that, it's just, again, that's why I wanted to bring up the thing about the culture. Why do you want a 704? Do you know that 3 others are still pending? Do you want to piggyback on those? You know, we'll work with you. So.
Nothing further.
Okay. Thank you, judges.